Hello and welcome to HR Talk, People Management's regular discussion about the topics making the news in the HR world. I'm Michelle Stevens and this week we'll be discussing the Agency Workers Regulations. I'm joined by Tom Hadley, the Head of Policy and Professional Services at the Recruitment and Employment Confederation, to talk through the new legislation. It is due to take effect this October and will entitle temporary workers to pay and conditions equal to permanent staff after 12 weeks employment. After extensive industry consultation, the government has just published its final guidance on the subject. So Tom, these regulations can appear to be a minefield for employers. What were the original areas of confusion and have the government guidelines addressed them?
Yes, they have to some extent. I think that's fair to say. I think if you really boil it down in terms of what matters for companies now that we do have the guidance, essentially it's about understanding whether there's an issue or whether there isn't an issue. And really we're talking about two or three important areas here. One is what are we actually looking to compare? And really one of the big areas of concern there has been what do we mean by pay for the purposes of the directive. So I think the guidance does make it clear that we are talking about basic salary that a temporary worker gets. That's one of the things that you need to compare. There's a little bit on top of that. So it does include certain bonus payments if you can link it directly to the individual's performance. We know that's included. It does include overtime rates, for example, and things like that. But it doesn't include a lot of other things. For example, organisational bonuses we know are out. So it's not as perhaps broad as it could have been, which is a positive thing. So one thing that guidance does do is make it clear what you're comparing. The other big thing for employers to get their heads around is how are we comparing and who are we comparing with. And the basic premise is this, is the question you have to ask yourself is how much would we be paying this worker if we were recruiting them directly? Okay, if we were going out to the market now to recruit somebody for this job, how much would we be paying? Not how much we're paying somebody who's already in our place of work, but how much we'd be paying at the point of recruitment. So essentially, in most cases, it's a point of recruitment comparison. So if we can get those two things clear, it enables employers to know, okay, have we got an issue in terms of direct pay? Okay, so that's some of the areas I think the guidance will help on and will help employers hopefully sit down with their agencies and look at an impact assessment, which in turn enables them to know, have we got an issue here or haven't we?
So does the guidance clarify the 12-week qualification period and who will be tracking that?
It does. I mean, it's an area that's relatively complicated in some ways to administer. So, for example, what's the definition of a week is something we've been into, quite some debate on. So any part of a week we know counts. What breaks the 12-week qualifying period is another area where there's sometimes a bit of confusion. I think the guidance does help to get our heads around that. The biggest single point I think is important, which is on a practical level, is actually, as you say, who's going to be tracking the 12 weeks. And the feedback we've had from the agencies that we represent is that's an area where the agencies will be carrying the load. They will be the ones putting systems in place to track it. They will be the ones contacting the employer saying, hey, the 12 weeks period is needed. We need to have a conversation just to check if there's anything we need to adjust. So I think we're quite clear on that. Is the 12-week issue is one that will create some bureaucracy, that will create some hassle factor, but it's one where the agency sector will be carrying the load and working with clients, but essentially, doing a lot of the running on that.
Critics have argued that this regulation has been gold-plated by the government and exceeds the EU directive requirements for small firms. Do you agree with this?
To some extent. I think it's maybe a bit harsh to say that. There's only limited wriggle room. So if you look at some of the areas that we were asking the government to tighten, for example, holiday pay, we were saying, well, that should be statutory minimum holiday. The reality is if it's specifically mentioned in the European text, there's only so far you can do to exclude it because you do run the risk of a European Court of Justice ruling. So some gold plating maybe. Could the definition of pay have been made even tighter? So it was more or less basic salary without some of the drift that we've seen possibly, but in the main, I think it's it's about 70%, 80% of what we could have hoped for as an outcome. If you look at everything, certainly the trade unions were asking for on this, it's actually quite a positive outcome. And the basic message, perhaps the most important message that we would try and put out there to employers, is fundamentally these regulations do not impact on the flexibility that temporary work provides. You can still terminate assignment if it's not working out. You do not have to give notice periods to temporary staff. You do not have to give redundancy rights or anything like that to temporary staff. So the model stays the same. So yes, there might be some extra cost, potentially some bureaucracy, but the model stays.
These regulations will be enforced through the employment tribunal system, and some commentators have warned there could be a surge in cases. Is this an accurate assumption?
It's a concern. So when we did our summit yesterday, 400 plus recruiters in the room, it was one of the issues that was flagged up. Now, we're actually quite optimistic that there will not be a big surge in tribunals. One reason for that is essentially temporary workers are often looking to progress in the jobs market. Are they really going to be looking to take tribunals? Not necessarily. Is the reward they'd get for taking a successful claim sufficient? Again, that's open to some debate. But more fundamentally, we think it's going to come down to the way that agencies and employers as well work with the workers on their books. So if you are very open, if you're very clear with the temporary worker what these regulations are about and what they're not about, if you've got a good internal mechanism for addressing concerns or queries from temporary workers, I think it sort of helps to really limit the potential risk of tribunals. In addition, we have spoken to ACAS, who've done their own analysis. They are not predicting a big surge in employment tribunals. And interestingly, the TUC themselves, speaking at our summit just a few days ago, themselves are saying, well, we are not expecting a big surge, and certainly the unions we don't think are going to be out there driving a lot of tribunal activity. So we'll have to see how that pans out in reality. But our assessment is no, we're not expecting a big surge. However, of course, we need to do the right thing. We need to make sure clients and agencies are working together to make that risk as small as possible.
Tom, thank you for joining us today.
Okay, thank you very much.
That's all for this week, but keep up to date with the latest HR news on our website, www.peoplemanagement.co.uk. Until next time, take care.